$20 a month.
I'd like to call the order of the workshop for the mayor and city council in the city of Tawnytown for the month of October, and ask Councilman Vigliotti to lead us in the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Welcome, everyone.
Thank you.
You're welcome. All members are here. Our city manager is under the weather, so he's not going to be here. First order of business I have is the review of the minutes for September 6th, September 11th regular meetings. Does anyone have any additions or corrections to those minutes?
No, sir.
Okay, they'll be presented for approval on Monday, or Tuesday, actually. As a reminder to everyone, Monday is a holiday, being Columbus Day, and our offices are closed. We'll be meeting the following day on Tuesday, as is our custom. Following a Monday holiday, we always meet the following day. Next, we have the reception of a delegate. We have Roberts Mill Run Stormwater Retrofit. Would you like to talk to us about that? I have no idea what you're going to say, but I'm sure anxious to hear it.
My name is Gail Ingalls. I work with Carroll County Government as the Bureau Chief for Resource Management. Along with me tonight is Chris Hine, our watershed restoration engineer for Carroll County Bureau of Resource Management. So we're here tonight to talk to the council and the folks of Tawnytown about a project that we're looking at working with Tawnytown on, and that's the Roberts Mill Subdivision Stormwater Management Retrofit. I want to give you a little background on the whole concept of why we're here tonight, and that has to do with our National Pollution Discharge Elimination System permit, which is a permit that's issued by the Maryland Department of the Environment, but it's based on the Clean Water Act, and it's really focuses on the Chesapeake Bay cleanup as well as our local water cleanup as well, making better water resources around the county at the same time. So we have two different phases of our permit in Carroll County. Phase one is Carroll County itself, the county itself, and the phases of the permit are based on the population. So Carroll County is a phase one permit holder because we have over 100,000 residences, and that does not include the municipalities. That's just the county itself. And then our municipalities within the county, 8 municipalities, all are phase two permit holders. And that's based on a smaller population growth in Carroll County. We also have other counties in the state of Maryland, and the State Highway Administration is also a phase one permit holder of the NPDES program. So since 2008, Carroll County has been involved in restoration works associated with our permit, such as retrofitting old stormwater management facilities, constructing new stormwater ponds. We worked on the Westminster Community Pond. I don't know if anybody's familiar with that or not, but we were instrumental in that project. And then we've also worked on several tree plantings. We helped the Boy Scouts plant an area up here in Tawnytown about 3 years ago. And we also have been involved in cleaning out storm drains and that's such thing to comply with our permit requirements. There's also other elements of those permit requirements that go beyond restoration work, but I'm not really going to get into that tonight. The reason why we're here is restoration work associated with the Roberts Mill Stormwater Pond. So Carroll County has approximately 8,700 untreated impervious acres, and what that equates to is blacktop surfaces, rooftop, and that sort of thing is not currently being treated by up-to-date stormwater management practices. That also includes municipalities as well. So the impervious area associated with all the municipalities are in that 8,700 acres. So back in December of 2014, Carroll County entered into a memorandum of agreement with all the municipalities in Carroll County. And the agreement basically was to bring you onto our permit, the Phase 1 permit. Now, what that meant was the towns would then not be responsible for treating their own impervious area, but we could incorporate your numbers into our numbers, and we could help with the restoration efforts in the municipalities. And when I say help, I not only mean financial assistance, but I also mean staffing assistance, obtaining permits necessary to do projects, overseeing the construction efforts and the engineering efforts associated with those projects as well. So the county then got the agreement together, and what basically the agreement says is that the county, Carroll County, will pay 80% of the restoration work requirements, and the towns are responsible for 20% of the cost. So along with that, we've committed to treating 50% of your impervious area that is currently not being treated. So your municipality would be responsible for treating 20% of your impervious area, and then we would treat 50% of that 20%. So we're looking at the Roberts Mill Pond as being a possibility for a restoration project. We've been working very closely with the City of Westminster, or excuse me, City of Tawnytown over the past year on this project. They actually provided us with a list of their existing stormwater ponds that they had trouble with maintaining, that were really not in the best of shape and were not functioning as they should be functioning. And we jumped on board with this project because it does have a large impervious acreage associated with it, as well as a large drainage area. So we then researched some grants, and we're always looking for extra money to help offset the cost of these projects. And we were fortunate enough to get a Department of Natural Resource grant. And what that entails is each of our municipalities, we currently have a project that we are working with them on. And the grant allows us to cost share with DNR half of the project construction cost for each of the projects in each of the municipalities. The grant that we were awarded totaled $3.9 million, and $1 million of that grant funding will be toward the Roberts Mill Stormwater Management Pond. So that will be funded with a grant for $1 million from DNR. So one other thing I did want to mention before I turn it over to Chris tonight to explain a little bit about the project itself. We did meet with the homeowners surrounding the property about 6 months ago in early summer. Jim was present at the meeting, and we met with approximately 10 homeowners. A mailing was sent out to all surrounding property owners that touched the facilities that we were going to be working on. And we met with them and explained a little bit about the project. We were planning on having some engineers come on board, and we wanted to make sure the residents were aware that we were going to have some activity going on up there. And they were very receptive to the project. They wanted to see the area cleaned up around their residences. It was what they considered as an eyesore currently, and they're very excited about it. We didn't really receive any negative feedback that night. We probably had about 15 residents present at that meeting. And our plans are that when we do have a preliminary plan design completed, that we will meet with those folks again just to get their input on what we're planning on doing around their area. So without further ado, I'm going to turn it over to Chris and let him talk a little bit about the pond. And then if you have any questions, please feel free to ask throughout the presentation or when we're finished.
See if this works. Perfect. So good evening. Before I really get into this particular project, I wanted to give you a little bit of background on stormwater management. I mean, everybody's heard the term, and everybody's seen ponds around the county and through the town and different types of facilities that are designed for stormwater management. But there are really two things that stormwater management does. One is it addresses water quality. It's the quality of the water that runs off our streets and off our roofs and goes into the streams. So there are nutrients and other pollutants that we want to clean those up before they affect what's in the streams and eventually, ultimately, the bay. The other aspect of stormwater management is flood control, or the quantity of water. And we've been doing that for here in the county and state for decades. The idea being that when you develop a property, more water runs off that impervious area and quicker and floods people downstream. So in essence, what you construct is a bathtub where the water fills up, the stormwater fills up the bathtub and gets released slowly out through the drain. So what we're looking at is the Roberts Mill and Sarah's Choice are the two subdivisions on either side of O'Brien Avenue there. And Piney Creek runs, or a tributary of Piney Creek runs through the middle. And there's actually a pretty good sized existing flood control facility there. The embankment is located. This is the embankment here, and then the pipe that runs through it is right there. So that facility was designed specifically for flood control, for quantity. So it provides no water quality benefit at all for the water that gets to it. And this is the type of facility that we like to look for in the county because it's an existing facility that we can then retrofit and improve on and add a water quality component to it so we can clean the water within an existing facility. It keeps our costs down somewhat. The other thing is that we like facilities that are in stream from a cost perspective because we're dealing with stormwater. We're looking for low places where stormwater accumulates. However, the Maryland Department of the Environment does not like to have facilities that are in stream because they look at that as a loss to habitat and loss into the stream itself. So whenever we find a facility that's already in stream, where MDE has already approved it at some point, that's another bonus to this type of project because we can continue working in stream and provide the water quality component that we're looking for. I guess I was talking too long on one slide. I don't know.
Can I ask a question while they're doing
Yes,
that?
absolutely.
You had said earlier that Tonytown's in the Phase 1 portion, but all other municipalities are Phase 2. Have I heard you correctly?
No.
What does that mean? Can you explain that again to me? Because I didn't catch that. Why would Tonytown be different than the other municipalities when Westminster?
I believe Carroll County's Phase 1, all municipalities are Phase 2.
All,
Okay.
including Tonytown's in Phase 2.
Yes.
Trying to upgrade to Phase 1.
Right, and when you entered into the memorandum of agreement with the county in December of 2014, you entered into a Phase 1 permit with us at that point in time. The one thing that I want to make clear is there were very few conditions that were different under the Phase 1 and Phase 2 permit that are currently issued now. Most of the same requirements existed. The only thing that didn't exist was the restoration effort, which the draft permit that's out now for Phase 2 has that restoration component in it. So you were about ready to get a 20% impervious acre treatment for the Phase 2, but it hadn't happened yet. So this was kind of like you came into our permit because you were going to be getting that 20% requirement within several months. So, but no, you were a Phase 2 just like all the other municipalities.
Okay, thanks for clearing that
Yeah.
up.
Shall we start it over?
And of course, it goes out right when I was going to start talking to the slide.
Want to talk a little bit about the engineering contract that we have?
Yeah, so when we decided that this was going to be a viable project that we were going to move forward with, we put it out to our, we have a group of 5 engineering consultants that we have on call with the county. We put that out to bid to those 5 consultants and selected Carroll Land Services to do the engineering work for us. And we also pursued a grant for the engineering component of this project. And we were able to obtain a grant for $75,000 that went towards the engineering. I forget what the total, I want to say 120 is the order of magnitude of the engineering cost. But we do have a grant that's assisting with that. And currently, they have completed concept plans. Actually, my understanding is that they just got submitted to our office today. So we will be reviewing those concept plans, and then the next phase will be preliminary. And once those preliminary plans are reviewed and approved, that's when we're going to meet with citizens, and would be happy to come back and meet with you all again and show you the plans. Once everybody is on board with the preliminary plans, then the next step would be for them to go to final and then construction. The time frame for this, we are potentially looking at working through the winter time to get the plans in place, and ideally next summer we would begin construction if everything goes well.
So many paths. That's the story of my life.
And you're saying that one of the reasons why you selected the site was because there was already an existing kind of infrastructure in place that you could retrofit.
Yes, exactly. And now what I'll show you on the map is that the footprint of the existing facility is not large enough for what we're trying to do. And so what we often look for then are roadway crossings, because that in theory is another impact to the stream. So we use that roadway crossing as where we can then work upstream of it. Now, O'Brien
Avenue.
Ave is interesting because it's a planned major street for the city that a connection would be made through. So what we're planning on doing is using that future connection as the embankment then for the facility. So from a permitting perspective, we will have to go work with MDE and, there we go, and get them to agree that we're going to have additional stream impacts by shifting the embankment essentially downstream 100 feet or so. But that will give us then the surface area that we need for the facility.
And so is it that you just looked at different municipalities and said, okay, well, these sites could potentially work for us? Or is it that you specifically said, okay, let's take one from each municipality to get everybody involved?
We found a facility in every municipality and so talked with each municipality as to whether those were good facilities for us to work with. And then we submitted the grant application en masse.
Gotcha.
May I ask how short we are from your goal acreage or size? How short are we?
I don't know that off the top of my head, but yes. Okay, so here we go. So there are, in the area footprint that we're looking to work, there actually are 4 existing facilities. The number 1 that I have labeled there, that's the quantity management facility that I've been talking about with the large embankment. Numbers 2, 3, and 4, those are existing water quality facilities that are older facilities. Number 3 actually has failed. There's a small embankment and the embankment is blown out. And I'm not sure that number 2 and number 4 are up, I don't think they're up to current standards. So we are not counting any credit towards our existing permit with those facilities. So what we're looking to do is replace all 4 of them with one larger facility that would use the O'Brien Avenue connection as the control structure. So go ahead and, so this is a rendering that we had our consultant do of what the facility would potentially look like. So it would be a wet facility, it would be a wet pond. The way water quality works in this type of facility is that the stormwater runs into it and the water slows down and spreads out and the pollutants settle out and settle to the bottom. And so then you have clean water that comes out through the rest of it. This would still provide flood control in that the pond would get bigger during large storm events and would run into the stream then and subside. So it would still provide the flood control, but now it would provide the water quality. Go ahead and hit the, just for some numbers for your benefit, there are over 300 acres of drainage area coming to this point. Of that, over 87 acres are impervious. So this is a pretty large drainage area and a lot of impervious area that we can treat. At its deepest point, the pool will be about 14 feet deep, but we would be looking to have safety grading. So it'd be, it's not like there would be an immediate drop off in the pond. If you chose to walk into it, it would get deeper very slowly for some distance before it then dropped off. And we're also looking to have a lot of vegetation around it to prevent, to discourage people from going into it. I mentioned that O'Brien Avenue would be the control structure. What you can see there is there would be a weir. This structure here, this line here, would actually be a weir, a concrete weir control structure. And it would tie into bridge abutments. So the two other lines are bridge abutments for a future bridge that when the town or city is ready to construct and make the completion of O'Brien Avenue, that could be done. So talking cost-wise, we have some very conceptual costs. Gail, if you want to hit the... So in general, we're looking at, in total, about $3 million. The facility itself would be around $2 million, and then O'Brien Crossing would be another $1 million. But if we're only constructing the abutments, which is all that we need for this project to move forward, that $1 million gets cut in half. So someday when the town is ready to make that connection, you would build the superstructure of the bridge and be able to cross there. And as Gail mentioned, we've got about $1 million already towards the construction. And these are very conceptual numbers. They've got 30% contingency built into them, so we're pretty confident that they'll come down yet. Okay. One of the amenities, excuse me, one of the amenities that we could possibly put in here is a walking path around it. Let me hit the... there are pros and cons to this. A pro would be that it would be a community amenity. It would potentially provide access for people going from Sarah's Choice to Roberts Mill. However, the downside is that it would provide easier access to the pond and it would be public access adjacent to private property. Okay. And so I just have one last slide here to show you what ultimately this could look like with the O'Brien Avenue connection being complete, where the bridge would be in place and connection between the subdivisions. So, any questions I can answer? Yes, sir.
Why is the county paying 50%? I thought your share was 80%.
Well, basically what he's saying is this project will cover 50% of the bridge crossing. 80% would be the county,
I
and
see.
20% would be coming from the towns.
Okay.
Yes, it's just 50% of the crossing. We would be paying for the facility itself.
The project begins when? You're ready to begin, or you need more funding to begin?
No, we have the funding. We're always pursuing additional grant funding. We're always looking for more grant funding. We like that. But our plan is, right now, our schedule is that we would be looking for construction next summer, if everything goes well.
And just so everyone realizes, this project will go out for competitive bidding, and we will also need to get commissioner approval before it moves forward with construction. So all of our projects, we go to the Board of Commissioners to ask for approval before we award for construction, and the construction date hinges on that approval. But this project has been in our CIP budget for probably 3 years now. So the CIP has been approved the last 3 years, so they're aware the project is in those budgets.
So the engineering at Carroll Land Service has been that's already been awarded?
Yes,
Has that begun?
yes, it has.
It is not completed yet, though?
It is not completed yet.
Okay,
Correct.
thank you.
Uh-huh.
Out of curiosity, the path that you were saying, you said that was optional?
Yes, that's something that we'd be looking for input from the residents that are there, as well as you all, as to whether we would want to incorporate a path around the pond.
I was gonna say, I guess my question about it would be, would it be more expensive to run a path around the pond or a path alongside the road and then with the bridge over top of the crossing?
Well, the bridge itself would not be constructed as part of this project. We would construct the abutments, and then so there's no way that a path could go across there until you all have the funding
Right.
to be able to construct the superstructure.
And then, so the path would be primarily for people who want to get it over between the communities before the bridge goes up?
Yes.
A leisurely walk path, really.
Yeah, it goes around the pond.
The final decision will be up to the town whether they want the walk path or not, because you have ownership of this facility and the liability associated with that.
Do you have any idea how much that would cost to put the path in?
It's negligible compared to everything else. Yeah.
I mean, we'll grade it in at the same time we do the rest of the grading, and it'll be put in at the same time, so to the community pond. So it would be
Yeah.
part of the project if you decide to go with it now, or when we do the construction.
Thank you.
I think the question I have is more for Jim. They've used a lot of buzzwords that we hear a lot at Planning Commission, and I'm wondering where Planning Commission needs to be in this project. 'Cause I feel like a lot of things have been done without Planning Commission being in the know here.
It doesn't really fall under the purview of the commission. The county is overseeing the project, and it's a county project, but essentially it's like any other stormwater project we would do on an existing facility. Those typically don't come before the planning commission when we do maintenance or work in the ponds that are already existing.
Okay,
So this won't go through a site plan process at the planning commission level.
so this doesn't, it's not like the senior center where we had to go through with the stormwater with them?
Our consultant engineer will be involved in offering review comments, but ultimately the county's stormwater management area will be have the final say on all of the stormwater elements,
Okay.
design elements.
Okay. What I'd like to see, I mean, we've talked several times about this O'Brien Avenue and the lack of a connection there. I'd like to ask the council if they'd be interested in maybe pursuing having a plan to immediately make that connection once the abutments are in. Is that something that we can pursue, or at least get a feasibility done on that? I don't want to see abutments sitting there for another 10 years, just like the non-connection is there.
This bridge was supposed to be constructed, and the developer defaulted on it
Right.
and left us holding the bag. And it's a rather costly project to build this bridge. We've looked into it in the past. Certainly wouldn't hurt to look into it again. But with the condition of the highway user revenues from the state, my initial reaction is that we probably don't have the funds.
Well, that's possible.
But I don't know what it would take to try to get an estimate on constructing the bridge. Certainly would be beneficial. And, obviously it was designed to be put in when the developments were put in, but it didn't get done. So, yeah, we should look into it again probably.
Yeah.
Well, I think it's not something we want to do now, but as they progress and let this contract and this weir gets built, I think your bidding process would be easier for an accurate bid once they're near completion. We are very blessed to have number 3 feature restored during this project, as that's good for our town, and also to have the upgrades and the retrofit come to Tonytown. So thank you very much for that.
Anyone else have questions for the delegation?
Yes, you have a pond that's flood controlled. You will have how long will we maintain the depth needed to still be passed by the state or whoever?
That's a good question. We have, we're going through a process of maintaining a lot of the county facilities over the past couple of years. And what we found is that facilities like this, which were put in place during construction of the development, that those have a significant amount of sediment in them. And so we're going through and we're dredging that material out. In this case, the watershed is pretty well developed, so I would not anticipate much sediment coming down and filling this up. So I think you'll have a much longer lifespan for this than we have in some that are put in place during construction. And when I say longer lifespan, I'm talking 20 years, 30 years, that sort of lifespan. Yes?
The way I understand it, you're gonna have a sloping pond, then it's gonna be 15 feet deep.
It'll be, so at the edge, it'll be very gradual
Right.
for, I think it's 10 or 15 feet. So if you walked 10 or 15 feet out into the water, it would still only be knee deep or so. And then it wouldn't be abrupt. It would be then we call it a 2-to-1 slope. So it goes 2 feet horizontal and 1 feet down. So it's relatively steep, but it's not a vertical drop.
Okay, you're gonna put a path around here, and there's gonna be little kids on there with scooters and balls and everything. Now you know that's gonna go in the water. When these kids run out there and then it gets deep, I see problems.
Right. That's the state requirement is for that safety grading, and the idea is so that if someone walks out, so if a small child walks out, they would have to purposely walk out 10 or 15 feet out into the water before it would start dropping off. So one would hope that they would be prevented from going.
You can't cope with children.
Well, and this is why, like I said, there are pros and cons to a walking path and access close to this. So that's something for the town to decide.
Well, and the other thing that Chris had mentioned, we're going to do some pretty substantial landscaping around the pond.
Yes.
And that should provide some type of a screening and hedge that would possibly catch. The other option would be if the town wanted to pursue some type of fencing around there, we certainly would take that into consideration as well versus a landscape.
I would be opposed to that.
But, excuse me?
I would be opposed to that myself. But
That's strictly up to you all, and you're right with the walking path, that obviously does attract people to come, and there is more liability associated to it. So if you don't want the walking path, please let us know that that's not an option. We don't have it in the plan to this point.
there'll be. You said there'll be time for public input before
Yes.
any of this is decided.
Absolutely.
All right. Well, we really need to move on with our agenda. I'll ask one more question if the audience wants to ask the delegation before they leave. Anybody else want to ask one more question for the delegation? Thank you very much, and we look forward to your next report.
Yes, thank you.
All right, the next item is the public hearing for ordinance 10-2017, outdoor displays and services in the downtown business district. Anyone care to speak on ordinance 10-2017? Come forward and identify yourself.
Good evening. I'm Robin Frazier from Bentley Street. I just wanted to, can I ask a question before I start? Does the city own the sidewalks, or do the business owners own the sidewalks?
Property owners own the sidewalks.
Okay. Well, I would like to say, first of all, that I am against the whole ordinance, but that being said, to look at the actual wording that's here, even the wording that was already there, I've never read this before, is troubling to me. The whole section 205-19 has a lot of subjective kind of words, and I think that laws should be well-defined so that people can understand what it means, and so that government can't be too wishy-washy on what's going on. So, for example, the purpose and intent of this district is to provide logical locations. Well, what is logical and who decides? For retail services needed by neighborhood populations. Needed by neighborhood populations. I don't know what that means. So it seems like that should be defined. The permitted use should generate low vehicular traffic with minimum vehicular parking needs. I would think that our main street, we would want to generate high vehicular traffic and have the problem of finding more ways to accommodate parking. If you want your downtown to be prosperous, then you need traffic to come through. So I don't understand why that would be part of the intent of our code. And then it goes on to say, and create few objectionable influences. Again, what are objectionable influences and who decides? For nearby neighbors. Maybe the nearby neighbors decide. I don't know, I'm not sure. So the only part of the new part that's being added, again, that I don't think is well enough defined is at the end of that paragraph. It says, or incorporate any improvements, displays, or activities that compromise public safety. And again, I don't know what compromise public safety means, and it seems like there should be some definitions, examples, or something. What is it that you're trying to accomplish in that paragraph?
Well, I guess the ordinance probably was written in a day when good judgment and common sense prevailed, but that doesn't really do that today, so maybe you're right. I think most people can determine what public safety is. I think most people can determine what a nuisance would be, and the question of the neighboring communities. I guess the purpose of the hearing tonight is not to address the ordinance itself, but the changes in the ordinance. So that's where we should focus. So if that certainly will be noted as you pointed out.
Well, and I would agree with you that most of the things that a business owner would decide about what's safe and what's good for their business, they would know and they would do, and so therefore an ordinance isn't necessary at all. And that I don't really have any comment on all these numbers, but I hope that the businesses were specifically polled for their input. And again, I don't think any of it's necessary at all, but if they agree with it, then...
The ordinance came from the businesses. They prompted us to develop this.
Okay. Thank you.
Mr. Mayor, can I give a little bit of history that I think is missing here? This all unfolded from meetings with business owners and property owners in the city, where they identified a need for them to be able to display their merchandise outside, something that has been forbidden downtown. It's allowed in other districts, not downtown, and what this is doing is allowing them to be able to simply display those items outside. That's all. And the catches that we're trying to put in here is just something, don't put anything out that's going to compromise public safety, that's going to cause injury, that's going to fall on somebody, it's going to blow up, whatever it is. I think that's important. This is something that businesses have been asking for a very long time. And if we want to be business friendly, this is a step we need to take in that direction. And I'm not exactly sure how someone could be opposed to it.
Well, I would just say that I believe what you should do is not prohibit them from using the sidewalk that they own, and that it should be up to them to have the liability that they need, so that if somebody trips and falls in front of their business, they're liable for it. If the town doesn't own it, the business owns it, and then it would fall upon them. So I believe that the regulations are unnecessary, and that what should have happened when they asked for relief was just to lift the prohibition from being able to display things on the sidewalk. That's what I was trying to say.
Anyone else have any comments?
Yes, I would like to make a comment. That it's true, most of this ordinance been in existence a long time. Only the words that are darkened on the first page and the second page are new language. The word uses is added to services, and then this phrase is added, or incorporates any improvements or displays that compromise public safety. Then the word entirely is stricken, and the word primarily is put in. I don't know what the motivation for that was. But on the second page defines what can be done outside, and I have problems with this. I'd like to be part of the hearing displaying that. It says outdoor displays of merchandise shall be limited not more than 60% of the lineal footage of the storefront. Well, I know that we had Christmas trees out in one of my more favorite shops, and they went across the whole storefront. So that would be made illegal to go across the whole storefront with those Christmas trees. I don't see why we did that. And it says, not more than 4 feet from the wall of the building, displays shall not narrow a public sidewalk to less than 6 feet of clear width. Now, I understand that. Then it says this little phrase, I don't know where this came from. It says outdoor displays of edible merchandise will be prohibited. I bought a bunch of asparagus from one of our shop owners that was sitting outside in a sidewalk sale this past year. Why in the world would edible merchandise be prohibited outside? Why couldn't the Stonehouse, for example, put cupcakes outside? I'm going to propose on Monday that we strike that entire last sentence, banning edible merchandise outside. These people who produce edible things, if they cook them, they have to have a permit from the health department. But I don't see any reason to prohibit that when trying to preserve ingress and egress for citizens walking on the sidewalk. I know that this particular merchant has been able to be a blessing to lots of families that live on here. And then it goes on to say outside food service may be prohibited by the Planning Commission. I don't want the Planning Commission to regulate what happens on a sidewalk sale. I don't know why we do that. I think the zoning administrator could identify things that violate the spirit of this without going through the Planning Commission, because that gets expensive. If we don't agree with the Planning Commission, then we have to do some legal action in order to try to overturn the Planning Commission. So I would like to strike the words Planning Commission and just say permitted, and take that out. And it says a sketch shall be provided to the Planning Commission. I don't like the idea of having to provide sketches to the Planning Commission. And I'm going to propose on Monday that we eliminate the sentence about edible merchandise and this idea that you have to put a sketch to the Planning Commission and wait for them to meet and vote and all that stuff about a sidewalk sale. I think that's overreach. And apart from that, I understand that we are addressing something that we've worked out through the group, but I don't want to super empower the Planning Commission.
Just a point of order, Mr. Mayor. I think discussion among council should probably wait for later in the agenda when it actually comes up for discussion among council.
That's a good
We're in a
point.
public hearing right now.
Not that I disagree with anything you said, but really this is time for the public to comment. We can talk about it later.
I haven't had a chance to
after we
speak
get
to
that
that,
input.
and I'm part of the public.
Yes, ma'am.
Hello, Catherine Adelaide, 9 Cortlandt Street. I'm actually glad you brought it up before because it gave me an idea. I guess just to clarify for the public who may or may not be familiar with enforcement of the zoning code, and just to confirm, a violation would be a violation of the zoning code and the enforcement would be through Mr. Wyprek, right? My concern would be to make sure everybody had the proper notice of that, so you didn't have people starting to call the police over these kinds of things. And again, it would just be, I mean, if you read it, you can scope it out, but I would just want to make sure everybody knew that if they're having a problem, a violation, they call the code enforcement officer and not the police unless it's really a police matter, just to not overburden our police.
Thank you.
So it'd just be more of a notice thing. I don't know if you'd add that or not. And then I would presume that, I think the outdoor food service will be great, that the Carroll County Health Department is gonna, they have to get a Carroll County Health Department license, I would presume, so I would
Well,
think.
there's food services and there's food services. If somebody sells asparagus and somebody sells snowballs, and there's somebody that makes meals. So there's, if they're licensed to make meals, they're not making them on the sidewalk, they're making them in their kitchen. And maybe carrying them out to
And
there.
just serving it, yeah, and
But of
the
course,
health-
you couldn't make snowballs either because you can't manufacture anything with equipment, is what it says in here, so.
Well, when I've done health department permits, they have different levels of food service, and they regulate everything, so I made, and then also, just the outdoor displays of edible merchandise. What came to mind, of course, we narrowly missed, having recreational marijuana at the state level approved, and so there's a lot of foray into edible marijuana products. I'm sure that's not what anybody meant, but I wouldn't mind seeing something so that further down the road, if it changes, somebody can't get smart with that language and start putting edible marijuana products out on the street.
Well, that's what our overlay is for.
Right.
That would,
Yeah, the distribution overlay for cannabis. Downtown's not within that. They can't sell anything cannabis-related downtown.
Correct.
okay,
It's outside of the overlays.
okay.
Yep.
We're good then, thank you.
Yep.
All right.
Good evening, Keith Reed. I guess we'll start out with just saying that, as Don said, the 60% of the frontage, I think, is a little on the small side. There are some instances where you might be at 100%, or some where you might be at 20%. So I'm a little concerned about that. I'm definitely concerned about the 6 foot of clear width. Jim and I had spoke about this yesterday and talked about it a little bit. If you walk up and down the sidewalks, there are numerous areas between parking meters and porches where you have 4.5 feet. There are spots between trees and buildings where you have 4.5 feet. Your interior doors on your house is a 30-inch door, 29 inches clear opening that a person can pass through. So if you multiply that times 2, that's only 5. The 6 feet, there's a lot of areas that you won't even, you're not going to be able to set anything out there, even if you do have a display area where you could set it. So I think that the 6 foot, is too large. And as Brad said, yes, it's all talking about displays, but again, do we want businesses to stay? Do we want businesses downtown? The Tawny Town, the state, everybody spent millions of dollars on streetscape saying that it was going to revitalize the downtown. There was going to be businesses coming in. It was going to help the businesses. And, it has helped some businesses. Yes, we have gotten some new businesses, and some businesses have stayed and some have went away. So I think that, we really need to ask ourselves, do we want businesses in Tawny Town, downtown, or do we want them to be, apartments or whatever? And again, I just want to talk about ordinances in general. We try to get these ordinances passed, and in a lot of cases, not disagreeing with, I guess, what Robin says is, we try to get these ordinances passed, and we're talking about 1 or 2 people or 1 or 2 businesses that we're trying to hinder what everybody else is just trying to do and have a beautiful storefront or a beautiful building, and instead of addressing the problem source. And you can't put everything in writing and in black and white. I was just wondering, as maybe you get more with sugar than you do with crap, whether the mayor and council would be interested in, once a month, somebody walking down through the town and just saying to a business owner, if something's a little askew, or you don't like the fact that, there's rotten cabbage sitting out front for sale or whatever, say, we're trying to beautify the town, we're trying to make it look nice. Could you just, display the best wares outside, put your best cabbage outside, rather than just an overall overview of you can't do anything. And, and again, maybe you would get a better result with doing something like that on a positive note, rather than trying to shove things down business owners' throats. It's tough out there, you know. Anybody that's in business up and down the streets in Tawny, and it's not just Tawnytown. I mean, you know, I go to Oakland, Maryland. Oakland, Maryland used to have a bustling community and stores and everything else. I was up there last year. They had vacancies in their storefront. They are coming back a little bit. It is better, but it's tough. And the more stuff we've shoved down their throats, and they're just going to walk away. And then we're going to have empty storefronts. Thank you very much for your time.
Anyone else care to make any comments? Council will have chance to make comments on this ordinance as we progress through the agenda. It's under the adoption.
Before you leave the hearing, as part of the hearing, I'd like to say one more thing, if I might.
No, we have our chance to talk about it later.
Let
That's for
council
public.
discuss this
Well, not
later
so
in the
Monday.
agenda. It's
No,
already on the
tonight.
list. We're going to have a
On your
chance to do
agenda.
that. This is
We'll,
for the
we'll all
public
get
to
to talk
comment.
about it.
Well, I want my comments to be part of the public hearing. Will the public hearing still be open?
But see, you're not
You're not.
part of the public.
You're a councilman. Your
Well, I
input
didn't give
comes
up
with
my
other
right to
council
be a
people.
citizen when I became a councilman.
All right. Let's move forward and talk about, hear from folks, anybody that has the, any comments on the non-agenda items, items that are not appearing on the agenda, and we'll have, I'll set my timer. I didn't set the timer on the hearing because I gave people the benefit of the doubt that they would stick with a 3-minute time limit, but that didn't work. So we're going to stick with a 3-minute time limit this time. So,
Barbara Cook. How about some good news? I have 3 examples of good news in Tawnytown. I'd like to talk about the short street between Lorianne and Sheets. It was filled with potholes, cracks, and all kinds of things. Somebody came along and smoothed it all out. That's wonderful. The other thing, second thing is where Antrim meets Trevanion. To the right, the trees curved over Trevanion, and any black or silver or gray car was in the shadows and could hardly be seen for years. Somebody's come in and brush hogged back about 20 feet, and that's wonderful. It truly is wonderful. And the third thing is, I'd like to talk about the Tawnytown History Museum. They put on a quilt show. It was classy. It had style. They had a woman there that is the wife of an ambassador to a country in Europe, and she gave us a tremendous talk, and she particularly talked about how there was a expo in town, and she had to go out of town 10 miles to have her show. They told her probably 100 people would show up. Well, at the expo, they had 4,000 people show up. At the quilt show, they had 5,000 people show up because the people say quilts tell us more about the American people than anything else. Thank you.
thank you, Barbara. That was very nice. Who'd like to come up?
Barbara Haltebrado, 435 East Baltimore Street. I have something positive to say too. We hear so much negative about our town. I am thoroughly enjoying seeing all the pumpkin people along the street. I slow down to see what their costumes are, and I think it's great. It gives a smile to people's faces. It puts you in the holiday, Halloween mood, whichever you want, if you're just fall or Halloween. But I think it's something positive for our town, and I appreciate Carrie Stottlemyre, who I read in the paper, was spearheaded it, and all the ladies that helped her. So I just want to say we do have some positive things in town, not all this negative all the time.
Thank you, Barbara. And it slows traffic, too. I think
It does.
we shouldn't discount that. Anyone else?
Gail Wilson, 28 York Street. I have to agree with Barbara. you just really need to make those pumpkin people more anatomically correct. No, I'm kidding. I have an issue that I wanted to bring up, and Heather kind of prompted me to do this, not that she suggested it, but concerning the water bills. I'm just wondering if there is a possibility that you can enact some kind of proposal or something that would allow a 5 to 10% discount on water bills to people who are over 65 or over 55, and those who might qualify income-wise, that are homeowners. She had called to warn me about my water bill, saying it was really, really going to be high. It wasn't nearly what I thought it was going to be, but it kind of sparked this idea in me that perhaps there was a way we could mitigate the impact on lower income and senior families who are on fixed incomes by doing something like that. Otherwise, as far as I'm concerned, this is the best town to live in.
Thank you, Gail. We'll certainly take that under consideration at budget time. Anyone else?
Hi, and I'd like to be positive if I had more time, but I have something that I have to say that's very important. I would like to suggest that we discontinue the government Tawnytown record. I call it the Tawnytown Pravda, because just like Russia, you're putting forth government ideas without having the ability for anyone to debate them. I was very disappointed, Mayor, in your message, which has, there have been falsehoods before, but this is so false and it's so wrong. And I've, disagree with having a government paper anyway, but this just really points it out. You write in here, the suit, and this is a lawsuit, contended that we had violated the Open Meeting Act when we called a special council meeting over a year ago to deal with yet another threatened lawsuit. The trial was heard in Carroll County Circuit Court, and the court found that the city did not violate the Open Meetings Act, but suggested 2 minor issues be corrected for future meetings. That is absolutely false. The court found 4 violations of the Open Meeting Act, and perhaps others. We're glad for those. We suggested some others that the court did not agree with. But here's one, and this is the judge's quote. The court finds it was a violation of the act not to tell the public that there was an open session at which they could attend to hear the vote or to hear the vote and any argument that would go into determining whether or not the body would go into closed session. So the court finds that there was a violation of Rule 3-302 that said there was no notice for an open meeting, which is required to proceed to closed meeting. They also said that
Mr. Mayor, she's talking about the lawsuit, and we shouldn't be talking about this in public.
No, that is absolutely false. I am addressing what the mayor wrote. And last meeting, he wouldn't let anyone speak about it, but he can write whatever he wants, and it goes to
Mrs. Frazier, you
every
have-
citizen in the town.
Mrs.
And
Frazier,
I am
you have
correcting
appealed-
false
There's a copy in the tri-district
information.
mailbox.
You have
And I
appealed,
want the
and the
people
Agora
to know
mailbox.
the truth, because this is false.
There is an
Have a
act
thank you.
of
And that's why we shouldn't have
have
government
appealed
papers.
the
And I'm not
cases.
going to be, this is why I've appealed the case, and this is the other falsehood, I'll tell you that in my last 23 seconds. We're appealing the mistake the judge made when he said you had an open meeting. There were no notice to the public, there were no minutes, there was no statement that had to be
You're
said.
talking about the
Two people were
court
turned
case. We
away.
don't have the ability to
Robin,
respond.
The counsel,
Simply your opinion.
under oath,
Court's
no, the
opinion is
counsel
different
under
than
oath
yours.
said that there was no open meeting. Only you and Mr. Gullo said there was an open meeting.
Please sit
And
down.
that's what I'm appealing, as well as willfulness,
will
which
have your
needs to
day
be
in court,
redefined.
perhaps.
And I will, and these are important things that need to be
Please sit down.
taken care of. And if Mr. Vigliotti hadn't interrupted
Please
me,
sit
I
down.
would have a few more seconds. And I'm used to being gavelled by you people that don't understand First Amendment rights. So thank you very much, Mr. Mayor.
Ms. Frazier's comments, I
I
apologize.
agree.
There's no,
When we get to the accounts payable, I'm going to talk about why you're mailing a copy to every citizen of your, you don't have a franking privilege to write whatever you want to write.
anyone else care to make any public comments? Gail,
Do you mind if I just comment from here?
can you, I can't hear you. You have to get to the microphone.
We
before I
can't
can
hear you from there.
It's okay here. It's okay. Thank you. One question. The Tawnytown Record, as I understand, is not a government paper. It's not funded by the government, correct? It's written and published by,
Main Street.
oh, Nancy does it? It used to be the,
It's Tawnytown Main Street that does it.
really?
And
But anybody,
advertisers pay for it.
well, but anybody can contribute if they wish, is that correct?
As long as it's not
Right.
a political agenda, yes.
Right, but anybody can contribute anything.
Right.
So if I wanted to put an article in there, I could do it, correct?
As long as it wasn't of a
Right.
political slant, yes.
Oh, yeah, but I mean, say I had something that I thought would be good for the public to know, or an event or something that I thought was important.
Well, let's be very clear. The council has no say in the Tawnytown Record.
Right,
Not a city, so questions like that need to go to Nancy McCormick.
right,
And my comments are simply my comments.
Right.
I mean, they're nobody else's.
right. So if I wanted to ask to put an article in that was for the public interest, I could do so.
We
Correct.
we can't say if you could or not. It's not our thing.
The editor, who happens to be Nancy,
Right.
determines the content of the paper.
Right, okay. I didn't think so, because after all, there are advertisements in it and everything else. I didn't think it was a government paper.
It's not a government paper.
Okay, I
That's
find
just,
it,
that's just hyperbole.
yeah, well, and I find it very informative in many cases.
Thank
Thank
you.
you.
Anyone else?
Catherine Adelaide, 9 Cortlandt Street. Yeah, it is, who pays for the ads? It is a government paper. If it wasn't a government paper, it would include an editorial. And you, Mr. Mayor, are violating the code of conduct because you cannot use your position as the mayor to proselytize and put your personal opinion, if that's what you're calling it, out to every citizen.
Oh, sure
it's
I can.
No, it's my comment time. It's my comment time. No, it's a government paper. And you can't put your position out like that because you're sending it to every citizen, and I haven't seen any numbers on who's paying for it. Plus, there's no editorial. Now, the Republican Women's Club of Tawnytown, we file a report with Nancy, and it's just that. It's a report. When you are writing, you're writing as the mayor of Tawnytown, and you're putting your opinion there. For example, you're calling the lawsuit petty or frivolous. And Mr. Vigliotti, before you object,
I wasn't going to say anything. You're the
Thank
one
you.
who brought me into this, but thank you for bringing me into this.
no, but thank you. That's not a discussion about the lawsuit. I can talk about the Open Meetings Act. It's not a discussion of the law. And first of all, Your attorney's concern is your response to it. This is a comment period. Actually, a citizen making a comment, they shouldn't be interrupted, as they often are, and they should be able to go all the way through, make their comments, and then you should listen to your attorney's advice, and if it's something regarding the lawsuit that you shouldn't respond to, then don't respond to it. But to say that citizens cannot speak on a certain subject has no bearing whatsoever.
So you think that it's perfectly okay for you to sit there and to browbeat us about something and then expect that we have no ability to
You just
respond in defense
interrupted
of
my
ourselves?
comment session again, Mr.
You interrupt me
Bigliotti.
frequently, Mrs. Adelaide.
I haven't interrupted anybody. This is my time as a citizen. So just to move on, I'm concerned about the pot factory that's in Tawnytown. Almost everyone I have talked to who is even in favor of medical marijuana, and again, I use the term loosely because medical marijuana, as it was passed in the state of Maryland, is smoking a joint and calling it medicine. Of course, they dolled it up now with eating some products or putting on some oils or whatever, but originally it was smoking a joint and calling it medicine. True medical marijuana is an FDA-approved pill called Marinol, which you can get from your pharmacist. Even they are not in favor of recreational marijuana. So my challenge to you is recreational marijuana narrowly was defeated at the State House. It's coming down the road. And when you could have exercised your muscle and your authority to push back on it, you haven't greased that wheel at all. So you all will sit here and tell me that you're not going to go for recreational marijuana. You've opened Pandora's box, and wait until you see what happens. You will not be able to stop recreational marijuana out on your city streets in about 2 to 5 years.
I have a question for you, Ms. Adelaide. What gives you the right to give your opinion on medical marijuana, and I can't give my opinion on the events of the town?
Can I answer that? Because I am a citizen doing a comment period, and you are the mayor of Tawnytown putting it out in a published record and publishing falsehoods, I might add. That's the difference between us.
I mean,
I'm not an
you're
elected
sitting there
official.
spewing falsehoods, and nobody's objecting to your
It's a comment
your
period.
vile comments.
What was vile about my opinion on medical and recreational marijuana?
It was completely off base. It made no sense. It was
It's a
irrelevant.
non-agenda item. There's a pot factory that came into Tawnytown. I'm warning the council that had you pushed back on the medical part of this,
Okay, thank you.
recreational is coming down. You're the mayor, I'm not.
Let's move on through the rest of the agenda.
Mayor, can I make a comment?
All right, one more then, one more.
Marvin Flickinger, 80 Baltimore Street. I usually side with the council on many issues, but when you say the paper is not a government paper, I think that Mrs. McCormick's in charge of it. And I like to ask the question, does Mrs. McCormick work on this paper on government time?
As part of her job as the Main Street manager,
So you authorize her salaries and so forth. So in that sense, the word, I view it as a government paper.
yeah. All right, let's move on to the agenda.
Thank you.
I need to ask the council if there's any items on the agenda that might cause a conflict of interest this evening. Anyone have any conflict of interest?
No, sir.
No, sir.
All right, moving into ordinances, resolutions, and agreements. Ordinance 13-2007, variance request. Review by the planning commission. Anybody have any comments in regarding
I
ordinance
have a
13-217?
If it's okay, Mr. Mayor. I'm delighted to see that the people who prepare our packets have followed the guidelines we discussed when I first got elected. It says that, that items that are omitted are crossed out, and then we use italics for new items, so you can tell when we get a draft what has been done to these councils, to these things. The variance ordinance says said application shall be reviewed by the Tawnytown Planning and Zoning Commission. Once again, I want to ask a question regarding procedures. Before we add this language here in italics at the bottom of page 1, what was the procedure used for a variance before? My understanding with the Carroll County is that the zoning administrator is the most familiar with the statute. An applicant comes into the office, they want to do something like build a lean-to on their house that is a foot too close to the building, to the property line. That the applicant applies and then is given advice by the zoning administration whether that's consistent with our zoning ordinance or not consistent with our zoning ordinance. And if the decision that they make is objectionable to the property owner, they have an appeals court they can go to called the Board of Zoning Appeals, and they can say, I don't agree with what the administrator told me that I can't build my lean-to because it's a foot too close. And they can take their variance to the Planning and Zoning Commission, get a decision. I hope you all understood that what I just said, because it prefaces what I'm about to say. The new language says the said application shall be reviewed by the Tonytown Planning and Zoning Commission prior to the public hearing held by the Board of Zoning Appeals. I think that's a new procedure that's not in the law, hasn't been in the law, hasn't been in practice. Just like I don't think that people have a sidewalk sale, have to do a sketch and bring it before the Planning Commission so a bunch of long-nosed people can sniffle at it and have their opinion about whether it's 60% or not. I don't think
We're not talking about that ordinance.
I
We're
don't
talking
think
about
that a person with a variance needs to
13-2017.
come before a separate committee before they go to the Board of Zoning Appeals. And I think this language is inappropriate. It's known as Section 1, Part 1, little a. Said applicant shall be reviewed by the Tonytown Planning and Zoning Commission prior to the public hearing by the Board of Zoning Appeals. This is new language for the purpose of giving advisory comments. I can imagine the Planning Commission would have plenty to say, and recommendations thereon. I've served on boards and commissions, and I've seen bad decisions come out of boards and commissions, and I don't think we should build another layer for people who need a variance reviewed by the City of Tonytown.
Okay.
And I would suggest that this provision of new language, which I think is the only provision that I see that's changed in it,
Thank you. Anyone else?
be removed.
Mr. Mayor, I'm very familiar with this. Coming as liaison of the Planning Commission, I understand what we're going for. Let me first clear up one thing that Councilman Frazier said twice about outdoor displays. I'm a little off topic, but it needs to be corrected.
We're going to talk about that in a minute, Joe.
Understood. I understand. But nowhere in the outdoor display ordinance does it say they need a sketch plan to have a sidewalk sale. And I encourage you to reread that because I think you're missing a lot of the key points in it. Now, what you just explained happened at the county level is they go to Planning Commission for a decision. If they don't like it, they go to the Board of Appeals.
No. That's not what I said. I meant to say, if I might respond.
Please do.
The zoning administrator is hired as a professional. They're given their most familiar staff person. We have an excellent one in Tonytown.
Okay, but
that knows our staff.
I'm interested in their
So
process.
an applicant comes in to file paperwork for a building permit, and they're going to ask whether it's consistent with the permit. The opinion of the zoning administrator, whether or not we have a problem or don't have a problem with a variance, is made apparent at that time because the advice is given from the professional staff person. And that's adequate. We do not need another committee to be in there doing his job. And I think it's a waste of time and government money and a potential for all sorts of difficulty to put you in there when what they can do if they don't like the opinion of our professional is they have an appeals board called the Board of Zoning Appeals, and they can go and then have another committee hear that. And we have members, they get paychecks here in a minute. I'm going to talk about all the Board of Zoning Appeal people get a paycheck and they meet. And people who have a problem with a variance will have a day in court, so to speak, with this quasi-judicial Board of Zoning Appeals. There's nothing wrong with that. If it ain't broke, don't fix it. What you're doing here is problematic and wrong, and I don't support it. It should be taken out of here. I don't want the separate committee to advise.
Councilman, I'm going to go ahead and take my time back
You've
for the
already
rest of my
said that.
comments.
Recommendations thereon.
You've already
I'm
said,
gonna-
you said that. You're repeating yourself.
I'm going to take my
Anyone
time.
else?
Mr. Mayor, may I finish my statement now?
Okay.
Thank you. That's not how it works in Tawnytown.
I know.
Oh. The Board of Zoning Appeals are for when people want to do something outside of what the code allows. Okay? They want a sign larger than what the code says they can have. They go to the Board of Zoning Appeals and they make the decision. Now, the Planning Commission, the way it used to be done was that it went to Planning Commission and they gave their advice. At some point in the distant past, that was gotten rid of. Planning Commission looks at it now. They're the ones who every single month are looking at the zoning. They're looking at the comprehensive plan. They're looking at all of these different things that the zoning appeals does not see, or they don't look at, because they only meet as needed. It might be 2 or 3 times a year, as opposed to Planning Commission, who are to be our experts for the city, who can then look at it and give their advice, not their decision, their advice to what they recommend zoning appeals either consider, just simply saying, think about how that sign's going to look compared to what's around it. That's our opinion. This is not for them to have a heavy hand and tell the Board of Zoning Appeals. The Planning Commission cannot overrule zoning appeals. It's simply to give the people who deal with this every month the opportunity to suggest other things that have to be considered. That's all it is.
Well, Mr. Mayor, I want to just conclude by saying that I have a different vision of
We've
what
already said
government
that,
should
Tom.
look like
We
than
know you have
Mr.
a different
Wayne's.
vision.
We have one board to review your application. We don't need this other board also viewing your.
There's no need to go back every time Brad makes a comment, you got to rebut it. You've already rebutted it. We
Well, I
understand where
want
your
the
position.
viewer to understand that
But we
there's
understand what your
significant
position
difference
is.
that's
So
being
you'll have the
proposed in this
opportunity to
legislation.
change this legislation on Monday night.
Mr. Mayor, if I could just very
Tuesday
briefly read for the purposes of everybody listening. The purpose of this, and I'm quoting, giving advisory comments and recommendations thereon, not decisions. They're not saying that, anything that we say has to go. They are providing an alternative school of thought. This is nothing more than advice, like Councilman Wayne said.
And again, it was unfortunate you missed last month's meeting when this was discussed, but this was all discussed during that period of time. That's why we're getting ready to pass it. Anyone else have any comments? All right, let's go to ordinance 14-7, or 14-2017, special exception request, review of the planning and zoning, similar ordinance. Anybody have any questions or comments on that ordinance?
Yes, I would like to speak to that. Once again, the same language is here. The plan and the application shall be reviewed by the Tawny Town Planning and Zoning Commission. This is new prior to the public hearing. This is new. This is not what we've been doing. This is new, and I don't support that. It's an extra level of busybody involvement in an application when we have a perfectly competent zoning administrator that knows the statute and would advise the applicant whether it's consistent with the plan or not. We pay for that. We have one of the finest. We don't need the Planning Commission's meddling in that.
Anybody else have any comments? All right, next we have Resolution 2017-15, Guidelines for Public Comments in Council Meetings. Now, this one came to me as a bit of a surprise. I didn't expect it to be here. I didn't expect it to be in resolution form. I think this is something that we could probably talk about, but I think we're premature as far as the resolution.
I agree.
And I'd just like to ask any of the council if they have any comments on that resolution.
Well,
no,
I
wait.
want to know,
I-
how did we get to a resolution before any introduction, discussion,
Amen.
planning, or anything?
that's right, Diane.
On this. Second, I don't think we need a resolution for guidelines. The mayor has put forth the way the public will comment, when they will comment, how long they will comment. It seems to be going well. I don't know why we need a resolution for guidelines for this.
Okay, well, let me speak to it because I'm the one that brought it up. And I have a great example for
You
it.
brought it up to whom?
Well, I've brought it up at 2 previous council meetings.
Right.
That it's something for us to discuss, and the council
Well,
agreed
we
to.
never had a formal discussion
And we're having a formal discussion
with the resolution number beside
for us
it.
to consider. I requested that Jay put it in the form of resolution for us to
We're
consider.
really not supposed to do that either.
I was going to say,
All
we
resolutions
individually
need to come
don't
from-
request that Jay put forth a resolution.
Sorry,
We
this-
discuss it.
This is what I was advised to do. I apologize.
Okay.
So, but let me give an example of why I brought it up. And a prime example is tonight. public comment session was not in order. It was not under control. There was screaming, there were attacks, all of the things that shouldn't be happening at a public meeting. And that's what this is trying to fix, that we can have civility from both
Yeah,
sides.
trying to fix. I don't think a resolution is
What
gonna
makes you
fix
think
that.
that behavior like that would
It
cease
won't.
if we had a resolution?
I would argue that it would give you stronger authority to be able to enforce order.
When you have, when
I have all
you,
the authority I
He's
need
got
to
the
enforce
authority.
order.
And this formalizes it.
when you attend a county meeting, there is a large sign as you enter the
I
room.
hate that sign.
Good. There is a large,
I don't
Put in
have
that
any,
sign.
I would
have any problem with
appreciate,
having a sign like that.
I would appreciate that I
I'm a
have my
citizen. I
time
pay
to
my
talk.
property taxes. I have a right to speak to my county commissioners. They can't make rules for what I can say and I
They
cannot say.
absolutely can. In the same way they can make rules that they don't accept public comment at their meetings. It's the same thing that
Then
gives
they're
them that
tyrants
ability.
then.
When you go in, there's a large board that gives the rules
stinks.
for citizen participation. And these are adapted similarly from what they have. So that when there's a problem, the mayor can simply point and say, our rules say you don't do this, please stop. Instead of being accused like he has been of making it up as he goes, which he is extremely consistent with his rulings. There needs to be something that he could point to so people aren't constantly badgering and yelling and accusing and trash talking, and it's from multiple people.
Well, it's a small minority who abuse this privilege, and
I disagree.
it's my personal opinion that flexibility needs to be built into public comment. And to limit it to 3 minutes every single time somebody gets up there, it might be better one time that maybe we only do it in 2 minutes, or maybe we should have 5. Depending on the topic, depending on the lateness of the hour, there's a lot of things in there that require flexibility. When you codify something, you're locked to it. And as the presider, I would much rather have the flexibility to be able to judge the audience, judge the content, and judge the meeting, to allow comments so that we can get the full participation of the citizens without undue delay or people getting up there ranting and raving and acting like strange people. So,
Well, Jim, I agree with you fully on that. I think that putting this in writing is going to make you famous, actually, for squelching debate. It's much better that the chairman is not boxed in and is given some latitude. That's your job, and I think you've done a good job with it for the most part.
Well, I'm going to absolutely disagree based on exactly what happened tonight.
It's not offensive to me that people have strong opinions.
That people don't have the civility to talk to the council. It has to resort to yelling and
not
attacking
civil.
and, oh, I disagree with you.
We're spending $60,000 a year on the Tony Town record. And somebody has a right to say that from that well during their 3 minutes.
And that's fine. I accept the comments. It's the yelling, it's the attacks on individual council members or the mayor, it's attacks on members of the public.
Grow up.
It's,
Get a thicker skin if you're going to be on the city council. People have strong opinions. I'm yelled at all the time.
and that's
I'm
what I'm
not whining
trying,
about it.
that's what I'm trying to fix, because it doesn't belong in these
Well,
chambers.
I don't believe
I
in
don't-
writing laws
Brad,
like this. This
I
is
don't-
bad.
I don't disagree there should be guidelines.
This is bad.
But I think they should be guidelines. I just don't think they should be codified.
I agree with
All right,
you.
so Mr. Mayor, on that note then, what would you recommend as a way to institutionalize some kind of guidelines?
Well, I think a handout or a meeting decorum poster or something of that nature
And that's all I'm going for.
could be posted in the room or could be provided as a handout as people come in. Something with some of this contact in there. But again, I
So you're not
would like
opposed?
to have the discretion to be able to run the meeting with some flexibility, without the rigid rules that are, once this is codified, that means we're gonna live with it.
Well, on the second page, there is a caveat that says that you can vote to suspend the rules, and then you can run the meeting as you see
Yeah.
fit. So if, again, whether or not this is in the form of a resolution or, like you said, simply guidelines that go up on the podium, we do need some kind of formalization of the rules, not just,
Don't disagree with that.
Yeah.
And that's all this is trying to do.
All right, well,
so,
let's,
well, let me ask you real quick. So if not in the form of a resolution, how would you propose moving forward? Just consensual agreement that we need something, or?
I think that if we prepared a list of guidelines or a summary of guidelines that could be put on a piece of poster board and displayed in the room, that would be perfectly satisfactory. And most people who have, well, I don't want to say that. Most people would respect that.
And that's all I'm trying for, Mr. Mayor.
Okay. Well, let's continue to talk about this, but I'd really encourage you not to pass a resolution.
Amen.
Well, it's only up for introduction, so.
Okay. All right. Now, ordinance 10-2017, outdoor displays and services in downtown business district. You'll have a chance a little bit later, Keith.
No, I just want to make one comment about this that we're not talking about.
I can't let you do that until the end. You get what public comment on agenda items, right down there at the bottom.
Yeah, that's good. I'll just say a word about this before we finish our workshop discussion of it. The things I brought up earlier during the public hearing, I want my peers on the council to take strong consideration of them. It is wrong to harass the businesses by saying they can only have 60% of the front. I think something would be more appropriate would give the zoning administrator authority to take down permanent outdoor displays. You could have to take them in at night, or you perhaps could have some zoning authority for him to police them.
Counsel-
But to put these things in this ordinance, they're offensive to our merchants, and I'm not in favor of it.
Well, we know that, but I need to hear from other council members. We know your position. Does anybody else have any comments?
I would just like to see some more discussion on just some of the ins and outs. You know, and maybe Bradley could be a little bit more specific about why they've chosen the 60% and, you know, just give us more detail as to how they came up with the specifics, because I don't imagine that they just randomly picked numbers out of the sky.
It's the way committees work. Committees sometimes do crazy things.
Well, yeah, it's similar to what we were talking about a minute ago. It's codifying something that probably may not need to be codified. Maybe there should be guidelines, and maybe there should be a piece of paper you can hand to the merchant, Jim, and say, these are the guidelines for storefront displays, and come out with a program like that. There's all kinds of stuff in here, like in this first one, the services shall not include any manufactured and production powered by machines or wholesale distribution facility. What does that mean?
Well, I was surprised to hear you say
If I've
snowballs.
got a machine that grinds ice to make snowballs, is that permitted?
Well, we had a snowball stand downtown.
All right,
Yeah.
we do. And under this ordinance, we couldn't have a snowball stand downtown.
It's
Because that's
problematic.
edible merchandise. We
Depends on how
display
it's
that out
mixed.
front.
That's the old ordinance.
I guess, Mr.
And I can give you some clarity whenever you're ready. I mean,
Now, do you want to address what the mayor
You're
says, and
awful
then I can?
quiet, Jay. Well, why don't you jump right in there?
well, I'm trying to abide by the let you guys do your thing. Okay. I guess to start with is this was a product, as the councilman said, that the businesses came to the city. Said, we want to put things outside. Because right now, you're not allowed to put anything. So you find fault with 60%. The current number is 0%. Okay? So,
Because our waiver ran out.
well, and the waiver was a tenuous way of saying, do people like to do this? And people did like to do it. And then we came back and said, if you like to do this, and it's really something that you want, we should change the zoning law officially. So that's what you're doing, is changing it officially from 0 to something else.
Is there a consensus among the business owners that this is the way it should be? Or, I mean, we heard from a business owner tonight that it wasn't the way that it
Well,
should be.
I didn't poll them. I was present at the Planning Commission when they came, and that people have come continuously to see the status of things. And this has morphed from what it was to this being the most agreeable situation. But a lot of people, when you read this, everyone is focusing on the words that are not in bold and underlined. And
The
that's
things that are already
existing law.
existing, right.
Okay, so that's there. If you don't like it, that's a subject for another day or another time, because nobody ever focused on that. The task was to figure out how to let people put things outside their businesses downtown. That was the task. So the ordinance was modified to make that happen, and that's why you see only certain things change. They weren't tasked with explaining other things or taking other questionable issues out. So that's the point of that. The 60% was the thought that if every business covered the entire frontage with stuff, whatever their stuff is, you're going to make the street look like the rummage sale. So they said if you put 60%, there's a break, okay? And there's going to be a break anyway because there's a door and the door entry and things like that. So what the Planning Commission chairman did, he did this privately, sat down with me, and he said, let's, in our minds, go up and down Main Street here and see how would this affect things? Because the one issue was timing. Should people have to bring things in at night? That was the original proposal. And they said, well, the one that's over here, those big things that are out there, nobody's going to carry that in and out at night. And if they're small things, somebody's going to take them at night if you leave them out. So the owner is going to solve that problem by bringing it in. So he walked, in his head and said, that's not going to be a problem. That, nobody's going to have problems with that. So then it came back to the second part, which was entirely versus primary. And the thing was that sometimes now this business items are going to be out on the street. So it's not going to be entirely in the building anymore. It's primarily in the building, but not. So that's just, like a logical thing. The big ones on page 2, the brand new language, which was the 60% of the square footage, and the 4 feet from the wall of the building, and the sidewalk.
An edible.
Well, we'll get to that. The issue with the 4 feet was that it is not measured, if you can imagine. So just pick a place out there and there's a tree in front of it. And there might not be the 6 feet that we're talking about in that section. But you get right past the tree and there is 6 feet, which means that where the tree and the building come together, you couldn't put something. But you go a foot the other way, you can put stuff. 5 is the minimum number, okay? You have to have 5-foot clearance for ADA compatibility. So they made 6. They said, well, we want 6 because it's a little extra. But you couldn't go less than 5 no matter what, because you're not allowed to put stuff right up to the curb anyway. So that's the reason they went with 6. Then the edible issue was some businesses, they weren't talking about like asparagus and things like that. They were talking about like food, like prepared food that wasn't cupcakes. They were like just brownies or things that were set out there that were like giveaways and things like that. And they said, this isn't the place where we want that to happen, okay? We don't want edible products to be served outside. If they want to have these things, all they got to do is put them inside. But we don't know how long they've been there. It just created an issue where they said, why do you want to do that? When all they have to do is take that same product and put it inside their store and it's done. Edible stuff is not the same as the outdoor food service, okay? I mean, you can see it's a different section. Outdoor food service is any place outside. So we'll pick a building like, just next door, whatever. Next door wants to open a restaurant and they want to have outside food service in the back, in their yard. This would allow them to do that, whereas right now you're not allowed to have outdoors food service at all. But the Planning Commission said we just can't have people putting things in their yard and having people do that. We need to at least see what they're going to do, so you need to submit a sketch plan. Similar to what the Georges did when they submitted their issue. They said, we're going to have people have breakfast in the backyard from their bed and breakfast. Here's where we're going to do it. Here's how it's going to be seated and things like that. And they said, yeah, that's what that point is. So while they both deal with eating, they're not exactly that. So then they said, well, what about if the bakery or the other place on the corner wants to put like a little settee table out? Could they do that? Yeah, they could do that as long as it doesn't take 60% of their frontage. Yeah, as long as there's 6 feet clearance so people can get by. And if they want to do that, they could leave the tables out and lock them, or they carry them in because we don't have a timing requirement. But if they're going to serve food outside, then they probably need to have a little sketch plan, because it's important to us to know that that's what's going to happen. 2 big picnic tables over there make a big difference than my little ice cream settee. That was what I got. The zoning administrator's here, if he has anything further to add. But this was an effort to try to accommodate what the businesses want, because right now our law doesn't accommodate what they want. And so, I mean, you can disagree and say it should be more liberal, but anything less liberal than this is what you kind of already have. So, right.
I guess,
Jim goes first.
I just want to reiterate what I had mentioned last month, that I'm kind of concerned about 60% being, the minimum. I certainly take the point as to why or how, the process involved to get to 60% was, but, my concern is, I guess, I think somebody expressed it earlier, that, if you have like a shorter, or, like a narrower building, you will not have the same amount of space to be able to display something that maybe your neighbor would. And I guess that, in a situation like that, it's like, okay, well, you might be able to put out the ice cream, what do you call it, a settee? Settee?
Right. Whether
But
that's something or not, I don't know.
maybe you wouldn't be able to put out like a bookcase full of used books or something, right? So that was one of my concerns. And the other concern, that I'll reiterate again from last month, was the idea that, you can't have something, the difference between the 6 feet on the sidewalk and then the 4 feet from the wall. If you only have a narrow portion of sidewalk, would you be able to like put a display up against the wall? Even though that would, by a very small margin, cut down on the space that you would be allotted with the sidewalk. Because we don't want to
address those questions if you have. So the discussion was, and I think this was, I'm not verbatim, but close, was that not every property is going to be able to take advantage of this to the same extent other properties are, because all properties are different. So you may have a very narrow storefront and your 60% is really small, where you're like the gun shop down here who has a really wide storefront, their 60% is bigger. That's just the way it is on Main Street. Somebody might not be able to put anything because their porch sticks out, like next door here, and there isn't 6 feet from there to the curb. That's the way that is. They're not going to be able to do anything at that location. So if you look at it from the business perspective, if you were a business and you're coming to locate here, and this is an important thing, it's going to be what do I want to do? If you're the coffee shop, you might want room for tables out there. But if you're the accountant's office, what do they need out front? So that's the point of saying you can't make one size fit all.
I certainly take that point, but I think maybe rather than saying 60, I don't know, there's just something about that number that doesn't sit quite well with me. Because again, and I'm not arguing that it's going to vary by case to case, but then we should have something that would be tailored to that kind of situation, not necessarily where you're going to measure the exact length or width of a building and then determine it based on that. But that maybe if you have like a narrower building, maybe instead of 60%, it's 80% or something.
Is there a way that you could say, without impeding traffic flow or sidewalk traffic flow or something like that, rather than, they'll put a number in there anyway, just leave it up to people's good sense to display the merchandise?
Well, I was next.
So they're not blocking the sidewalk.
To both your questions, you could come up with any number you want. However, trying to come up with a formula is probably overthinking this. I mean, that's the thing, is that if you take this out of what we're doing here and think about reality, people want to sit stuff in front of their business. So if you say, I don't like 60, I want to go with 90, I want to go with 100, I mean, it really makes no difference, but that was the idea, was the break.
Practically, who's going to get out there with a tape measure and decide whether it's 60% or not?
Hopefully, nobody has to, because they deal with their common sense.
63%, that's got to come off.
But if a complaint comes forward, there needs to be something where Jim Wyprek can look at it and say, the code says this, you're this, people have a problem, and you're violating the code.
If you want to make it easy from an enforcement standpoint, then you say 100%. Or we tailor it so it doesn't have a percent, but that's the easy thing. But Mr. Wyprek's comment was, I hope it doesn't come down to him with a measuring tape. But you said, what about the traveling through there? Can we leave it to people's good sense? No. because it seems that the people lack a lot of common sense, and next thing you know, it encroaches out, and now you can't get past it, and the citizens are saying, hey, I want to walk down Main Street, and I can't get past the rack of clothes, which is going to generate a complaint, which is going to come back to him saying, it says in here 5 feet or 6 feet or whatever you want it to be. It doesn't have the vagaries, which we heard earlier. We're trying to make it empirical. And like I said, 5 feet is the minimum. So, you know, you can't go down to 4 feet because now you don't meet ADA. So.
Mr. Mayor, I want to speak to that. When this originally came up, I had just been elected to the council. We found out that sidewalk sales were illegal, okay? And I had heard a lot about it during campaigning. My suggestion to the powers that be was you take the word are not allowed and just change it to are allowed, and then give the zoning administrator the chance to do what we did during the trial period, which is to find out if people abuse it, and then come up with some sort of guideline. But what we've got here is very problematic. It picks on specific merchants that do specific things. It puts the planning commission with a sketch in the way of his authority, and I do not support that kind of a structured process. I think it harasses merchants. And I said earlier that I would make a motion on Monday to omit the final sentence in 7 that talks about edible merchandise, and this portion, starting with the word planning, in section 8 on Monday. I hope my colleagues will support me, because it's very problematic and discouraging to our merchants.
There's nothing we need to do more than to support our downtown businesses if we're going to have a successful downtown. And this is a step toward that direction. I'm not convinced that we got it right yet. So think about it between now and next week and bring back your suggestions, and we can modify this as you see fit. Okay. Next, we have Resolution 2017-14, the water resolution allocation.
I move we pass that.
We're not voting tonight.
Can't do that. Do we have any questions on it? Usually we can all agree on this one, but not always. Is anyone have any questions?
We talked about it already.
City manager's report. Of course, the city manager is not here. He mentioned to me that the process has begun to advertise and make known that we were looking to hire a treasurer to replace the one that has resigned. And more will be forthcoming on that. He has notified Maryland Municipal League, my suggestion, prior to the fall conference, simply to, in case somebody that might be interested from another city or town might have a chance to talk to us when we're down at the conference. So that's, and then it'll be advertised in various publications after that. But when he gets back, he'll give you more detail on that. Any question on any of the departmental reports?
I'd just like to compliment the IT director. If you study his report, he does an excellent job of telling where we are on these programs, and I'm thrilled with the way he prepares the report. I'd just like to say that as a compliment to our staff.
Okay. Legal report. Jay, what do you have for us?
Very brief things. One, you need to close the public hearing, because we need an official closing of the public hearing.
Oh, my goodness, I certainly do. I hereby close the public hearing regarding ordinance number 10-2017.
Okay, and then the second thing, when we're on the hearing topic, is if we're going to move ahead, and you can decide on Monday night how you're going to move ahead or not on the 2 ordinances dealing with the variances and the special exceptions, the next step would be to schedule a public hearing on that, and that day would be the work session on November 8th. So if you so choose to move forward, what you're deciding then on next week would be when to set the public hearing. It would be the 8th is the soonest. That's all I have.
All righty. Any questions for Jay? Let's move into new business. Anybody have any questions on any of the items on the monthly financial report? Hearing none. Anybody have any questions on the accounts payable?
Accounts payable is the check voucher register, right?
That's right.
Good, I always get that mixed up. I want to ask this question on, this doesn't have page numbers. Yes, it does. Page 7, on September 19th. It says Carroll County Times subscriptions through 4/2/18, $41.60. My question is, how many subscriptions do we have of the Carroll County Times coming to the city office if we only pay through April, costs $41.60? I've been encouraging people not to subscribe to the Carroll County Times. They did a bad job on covering Tawnytown so far, and I don't know why we'd have multiple subscriptions.
I think that's only one subscription. Looks like a 6-month subscription.
Yeah.
Well, why does
sounds
it say
like 6
through
months.
4/2/18? Does that mean that's a monthly charge?
No, I think it's,
They pay you, when you subscribe to the Carroll County Times, they allow you to pay it quarterly or semi-annually or annually.
Oh, so it may be a
That looks like a
semi-annual.
semi-annual payment. to me.
Okay, for a single subscription. All right. That's good. All right, thank you for addressing that. It may be, I didn't even imagine that it might be a semi-annual payment.
Okay. Anybody else have any questions? Next in your packet is the bid recommendation for the street light retrofit program. You'll see that, it's the last item in the packet, I believe. Anybody have any questions on any of that? All right, well, that'll be up for approval on Monday night, too. We have some time for public comment pertaining to agenda items. Keith, did you have something for us? I do. He tried to jump in and disrupt the order of the meeting, and I didn't want that to happen.
That's fine. So on Resolution 2017-15 that we're not talking about, just on number 1, if you can just put public comments rather than open to all citizens of Tawnytown, because I resemble that remark, or I don't resemble that remark, and I like to be able, I know sometimes you guys don't want to hear it, but I'd like to be able to make my comments anyway.
You're always welcome.
Mr. Reed, do you live inside of Tawnytown or not?
I do not.
Okay, that's not right then.
So
Because he has a major interest in Tawnytown to speak at these meetings.
that's correct. So I'm just saying, I know it's way premature, but I'd just like to, if we can just, all citizens of the city of Tawnytown, just scratch that would be appreciated. And then the last thing for consideration, back to the sidewalks, I'd like it to really consider maybe 5 feet, if that's the ADA, rather than the 6, because I think in some situations that might allow a business owner to put something out that they wouldn't be able to do. And with the ADA, I mean, I'm not, the law, but I mean, we have parking meters and buildings that aren't 5 feet, and up at the corners, we don't have 5 feet going around, so,
And the liability for that encroachment would be on the property owner, not the city, so.
What is the opinion of the 60-foot,
60%?
60%?
I mean,
I'd like to hear your opinion on that.
Again, as Jay said earlier, you've got a doorway. You're not going to have stuff in front of the doorway. We have some storefronts that are only 12 or 15 feet wide. Now, I don't really think that you need to put that variable in there. I think you can just strike that completely. And as far as whether the business owners, I talked to a couple business owners. They didn't know that this was going to be up again tonight. I tried to get some to come. So it wasn't really put out to their opinion of whether they wanted 4 feet from the storefront or 6 feet of sidewalk or 60. I mean, I think you could go down the street tomorrow and ask everybody on the street, and you might get 10% that might know that was asked what they would like to see this be. So
I have a question.
Thank
Mr. Reed, is it true, the rumor I've heard, that you've acquired the Chinese restaurant building?
1 York Street, yes, sir.
I would applaud him for the great job he's done on some of the other buildings that he's been working on, the new porches and things. Thank you for making Tawnytown look better.
Well, thank you, sir. I appreciate it. And 1 York Street will hopefully follow right in that
I
path.
know, we're behind you 100%.
Thank you.
Marvin?
My question will ultimately lead to Jay, but we remember when Streetscape started, the ADA got involved, and they had to have sidewalks in compliance with their regulations. I was told that it had to be wide enough for 2 wheelchairs to go by. You've heard that, I'm sure you have. Now, some of the porches that stick out, that question come up, I'm sure they would have been grandfathered in should a lawsuit arise of some sort. But those streets were made wider, which cut down on several parking places, and also made it impossible for some vehicles to park along the main street there. I know 2 vans that had their mirrors taken off. So there's many reasons why business is not like we would want it to be downtown. We don't want to admit it, but there's many reasons. I don't want to get involved in that. But if things are set out on the sidewalk and they're within that 2 wheelchair range, and somebody walks down there, some kid on a skateboard or whatever, hits something and gets hurt, my question is, who is liable? Is it the property owner, the business owner, or the town for not enforcing the ADA regulations?
Answer?
You can answer
Well, it's
that.
not the town. That's the best part, because we should not be responsible as a group for somebody's actions. It's probably going to be the property and business owner, if that's who it would be, depending on who did it. The town sets its regulations up, but the ADA is not enforced by the town. So we had that situation dealing with the History Museum, and it's enforced either through the Justice Department or private action. So if somebody came along with their wheelchair and said, I can't get through here, it doesn't have to be a wheelchair. It could be somebody who is seeing impaired, and they can't get through here. They could go after the business owner and the property owner. You know, we want to avoid that, because what would be the obvious thing somebody's going to say to the city? How come you didn't tell me I couldn't put my stuff out there and block the road and not be in compliance with ADA? So that's why we're trying to set a thing to say, the city's telling you, don't go past this.
The 2 wheelchairs side by side is going to be at least 5 foot.
That's 5 feet is the...
At least 5, maybe
That's-
even 6. I don't
That's
know.
their rule, I think, is 5 feet, and that's 2 wheelchairs side by side.
I've never seen that happen, but that's the law.
You probably wait to pass like you do on a road, but you're right, that's the law.
All right. Anyone else?
I would like to support the man on the rotten cabbage situation.
Okay.
No rotten cabbage. You want to write that in there.
The rotten cabbage.
Rotten cabbage.
Okay.
He suggested that you don't make rigid rules, just walk down and say, take your rotten cabbage inside.
That's good.
Anyone else care to make a comment?
Catherine Adelaide, 9 Cortlandt Street. I'm going to just want to speak exclusively about this guidelines for public comment at meetings. You're probably not surprised by that. First of all, the process, again, the fact that Councilman Wance did this independently, and I'm all for showing kindness and mercy and taking you at face value what you said your intentions were, Councilman Wance. But my concern, as always, is that had Councilman Frazier done the same thing, whoops, I think somebody accused him of doing that, and then he was censured. So, you know, you talk about the civility thing quite a lot, and I'm glad nobody tried to hang you out tonight, Councilman Wance, because it just wouldn't be proper. And I would just like to see you all keep taking the lead on showing that same respect to your minority Councilman Frazier. So that's enough said about the process. In terms of the content of this thing, I don't think I can express how much big trouble you're going to be in if you pass something like this. You're starting to go down the right road of backing off it a little bit, maybe a sign or whatever. The first one, a number of these are going to land you in a lawsuit faster than you can shake a head at. I guarantee it. When you say open to all citizens, you just threw out, it was addressed to at least every business owner who is not a citizen in Taneytown. And when I ran for council, I talked to almost all of them, and only a few were citizens. And there was a great concern of mine, even as a candidate, about how to give them a voice. So that's part of the problem, but it also appears that much of this is, again, being used to target and suppress speech of people that you don't like or people that you don't agree with. And, I mean, you know, soon we'll have you can't drive through Tawnytown if you're not a citizen. This is a public meeting. Anybody should be able to come and make comments. There are people that are following some of the constitutional issues that live outside of Tawnytown, and they should still have a right to speak. Thirdly, and even Montgomery County lets people vote without being a citizen. So I really hope I think number one is the one I'm having the most trouble with. I hope the comments will go to 5 minutes. Shoot, I'm running out of time. 5 minutes would be great. Number 4 is ripe for abuse, to shut down minority opinions. I think number 5, you got a free speech challenge on about signs. And you can't have it both ways. If it's not a question and answer period, then you shouldn't be able to interrupt people when they're making comments. They should be able to make their comment, and then if you want to ask them a question afterwards, you can do that, because when you interrupt, you also begin to escalate maybe the decibel. You could get a decibel meter if you want to get that crazy about it. I'd like you to define what strange is. Again, my concern with the whole thing is that it's ripe for abuse and targeting of people that you don't like. Thank you.
Take one more.
Robin Frazier, Bentley Street. Just on the guidelines for public comment, I just wanted to mention that as a county commissioner, we allowed people to say whatever they wanted to say, hold up whatever sign they wanted to hold up, use whatever decibel they wanted to use. And we listened because everybody has their own way of expressing themselves. Judy Smith used to get up every week and say, I offended her because I prayed in Jesus' name. And we would just smile and let her say that. Mrs. Orenstein used to come in with flip-flops on a stick when Shoemaker was flip-flopping on the airport. She gave us switches for Christmas and told us we were all bad, you know? So, you know, that's okay. You're supposed to hear from the public and from your citizens and then do whatever you want with it after you hear it. So I wanted to also go back to this sidewalk thing. And this is what I heard in the discussion. There's already regulations in place that define what you're trying to define in your ordinance. There's an ADA regulation that says 5 feet. It's already there. If someone violates it, go to the authorities that deal with ADA. There's already the health department that deals with food issues. Somebody violates it, go to the health department. It's already in there. The one that you're having trouble with is the 60%. And, you know, I heard from one of the citizens that why make it 60%? Why make it anything? Each property is going to have some factors that keep it from being 100% anyway. You have your doors, you might have a tree, your porch, whatever. So every property is going to be a little different. So to me, all of the issues that you're trying to address are already addressed in other regulations, and you should just eliminate that one, which would be good. Smaller government is good. Thank you.
All right, thank you, folks. I've got 2 minutes. I'll have one more before the bottom of the hour. All right, hearing nothing, may I have a motion to adjourn?
I'll move, we adjourn.
I'll second.
In favor, say aye.
Aye. Thank you, Mr. Mayor. It was a good meeting.
See you all Tuesday. Have a wonderful Columbus Day celebration.
Tuesdays are terrible for me.
Are they really?
I gotta coach my softball.
What time's that at?
That is from about 5 to 7:30.